We're back on. This is the Vanburen and Tyra case, B519168. Mr. Root, what do you got as far as time on your cross?
Oh, just a couple minutes, sir.
Well, I hope so, because you're going to cost your client another trip back for another session if we don't wrap this up soon.
Oh, I'm gonna wrap up soon here.
Let's go.
School started on August 24th, 2015, right?
I'm sorry,
Is that right?
August,
24th.
okay,
Is that true?
yes.
Okay. And was Dustin going to school from August 24th to October 21st?
They had to do an IEP, no, he was not.
Okay. And October 21st was the first day you decided to send him to school, right?
No, it was through the IEP, they have to place him before I can put him in a class.
And that date was October 21st, right?
It was right after that, it was the 16th of October, I believe.
And October 21st was also a court date, right?
Was it, yes, I guess, yes.
And Dustin wasn't in school this week, was he?
Yes, he is.
Was he in school every day this week?
No, he was sick Friday.
Okay. And that was last week?
Yes, and he was also sick Monday. Jason seen him, he was sick.
Okay. Your Honor, for the purposes of time, the court is right. I'm going to stop there. Pass the witness.
Any redirect?
Does the court wants clarification of some of these issues, or?
I mean, we can spend days, I mean, you're arguing the same facts. It's just a question of argument on the evidence. Is there any factual issue that really is in dispute that you're going to be able to resolve after almost 7 hours
I'll
of
pass the
testimony?
witness, Your Honor.
All right, you can step down.
Okay.
We have, during the last 2 sessions, heard testimony that spanned almost 380 minutes, or 6.5 hours. Are there any other witnesses or any other documentary proof that needs to be considered by the court?
Your Honor, only one other thing, I don't think I made it clear that if the court so desires, my client wants the name hyphenated, the boy's name hyphenated.
Let's go over that because is he on the birth certificate of the child?
No, Your Honor.
All right, so that's business that will obviously take place. The mother named the child, and the child's legal name is what?
Dustin, Tyra.
No middle name.
Does he have a middle name?
Oh, yes, Daniel,
D-A-N-I-E-L?
yes.
Okay. Now, the court is going to be left with a need to make a decision to leave the name alone or to modify it in some way to allow the child to identify with both parents. This is done when parents are in the hospital together and they acknowledge parents. So this wasn't raised in the trial. But Mr. Balvon, have you had any discussions with your client or with Mr. Root about what her preference would be as far as the name? Yeah.
Can I speak, Your Honor?
I'm not really asking for testimony.
Okay.
I'm asking for your position. What's your stated position on the name?
It's just, okay, the name thing is for the last name to be after the father, and
No, it doesn't. That's not what he's saying. I think what Mr. Vanburen is saying is that he wants.
I'm
his
okay with
name.
it.
All right. So let's talk about the detail. It is common for folks who are not married to have a name of a child so that the child can properly identify with both parents. When you picked Dustin, I'm sure that was important. Daniel, was that an important name related to somebody?
My father.
All right. So we don't want to disturb those. Do you have any objection to hyphenating the last name to include both of your names?
No, I don't have no problem with that.
Okay. So Mr. Root, what did you have in mind?
Your Honor, Dustin, middle name, Tyra, dash, Vanburen?
No, Dustin Daniel's going to stay the same.
Yeah.
But if we, I mean, I guess he'll have trouble when he fills in his bubbles on his test and a lot of letters. But you're talking about Tyra Vanburen with a hyphen?
Yes, sir.
And that's with a small b, right? Not a capital B?
Capital B, one word.
V-A-N, capital B-U-R-E-N.
Yes, sir.
All right, thank you. Is that how you want it to be on the birth certificate?
Yeah, I just want my name on the birth certificate.
Well, it's going to happen.
Yeah.
And
Yes, sir.
this, not only are you going to be listed as the father, but the child's name is going to be changed to have the child identify with both of you. It looks like all of his records at school under Tyra, right?
Yes.
All right, so Tyra Vanburen is just a semblance of that, and that would be fine. Okay, good. Thank you for bringing that up, Mr. Root. Any other detail or, I guess, non-physical placement issues that you want to raise with me before we get into the argument over physical placement or custody?
Did the court want to hear anything? Well,
Well, let me ask this question too of you while I'm thinking about it. This is the time of year when the independent educational programs are developed and approved, and parents don't have to take these meetings together, but it's very common for parents to take the meetings with the school. Is Dad in the loop with the discussion with the principal to get being part of these meetings? With the, like for instance, we didn't have any testimony concerning this, but one of the things that Mom raised was the child having a reaction to a medication that's given to somebody who's schizophrenic or has bipolar disorder or whatever, and I'm going, where the heck did that come from? Because there's not any diagnosis or any other kind of testing, related to that. It's an odd, thing. She's talking about medication that's being promoted by the school to help with behavior or help with whatever, so. Also, is Nevada PEP involved in this case at all?
They were at one point, and,
Well, let me just comment on it this way,
okay.
is that the battles that have been fought concerning this child's education and placement have been carried on by Mom, because Dad has not been invited in that process or been part of that process, but that's all changing, and frankly, you can argue over all of the themes of custody and placement, but we're also fighting a battle as parents for the benefit of their child. And this is not a battle waged by one parent when we have two parents who are available and we do that, okay? So, in as much as, I get it, that there's a feeling that a lot of these participation or interest is for the purpose of strategy in this case. Well, this case is going to be closed as soon as I can get it closed. And so, what I'm trying to tell you is to set those feelings aside as much as you can as it relates to that. So, and Dad may be able to actually really help the child by being a different voice. When the school hears the same voice all the time and the same arguments all the time, they may tune you out, and or may know how to resolve issues, and so not only is Dad going to be given all the legal rights and ability to fight this battle, but he should. And of course, that assumes that the child is here in Clark County and the school district here, but California runs the same way as far as public education. So the dialogue you're having with the principal, you don't have to have it with him, but he has to be involved. The principal has to be told, these testing referrals, when you challenge there are administrative rights that parents have to challenge the recommendations and findings of the school district. So you may be set up for that kind of fight. Okay. The testimony of the folks that testified is sufficient for the court to be able to take this case. These are very, very difficult concepts. We're trying to establish a custody order about 6 years after the time when it should have been done. Also, Dad, by all accounts, is doing very well where he is and has improved his employment and income and everything else. The problem is that he's created this dispute because this is the kind of case where a shared arrangement would be best for the child when parents live near each other, and that's not going to happen. And so it forces you to fight what we call a zero-sum game, where there's going to be a loser and a winner as it relates to being able to spend daily contact with the child. So that's why we had to have a trial with Dad saying, I want the judge not only to conclude that I should have custody, but also the added burden of having to remove the child from the state, which is the policy behind that is very strongly in favor of making sure that a parent who wants to do that can justify it. Mom is seeking to establish a custody order where she would retain primary custody, which she's had for 6 years. So there's I want counsel to try to offer your argument, that would kind of tie up all the loose ends from your case's point of view so that this matter can be submitted. These are important cases. On cases like this, I almost always will write out findings and conclusions to try to explain what the decision is. It takes a little while, a few hours, well, sometimes more than that, to do it. And this is the kind of case I would have to do that with. I have to talk about concepts of what the implications were to the paternity findings, to the custodial orders, child support orders, and the protective orders are not custody judgments. In other words, they did not create precedent as it relates to physical custody, but they also are consistent with mom having physical custody, which really isn't a factual issue. Dad's going to be conferred equal rights in the final judgment. Both parties are going to have joint legal custody, and we'll try to explain what that means, especially with the special needs child as it relates to that. Physical custody is the important contested issue in this case. And whatever the physical custody order is, the court would look to try to maximize the contact between separated parents and the child. You know, when you have a child that is young and has a school schedule, you are limited by the school schedule, but also with the special needs, there's a lot of responsibility that goes with not only the transporting of the child, but dealing with the emotional effect of changes in routine and everything else. But I'm speaking more to mom more than anything, is that the inconvenience or the difficulties related to transition is expected in cases like this.
Yes.
And we're not gonna regulate or limit dad's time because it might be difficult. Okay. Mr. Root, are you ready to offer your closing argument to the court?
Yes, sir.
I'll hear it.
Your Honor, first issue is what has Truax or Ellis. We believe either one is fulfilled. In Exhibit 1, there's no specific custody award, no joint legal language, no visitation, just a child support order payable to California Collection Department. Because it doesn't comply with 125C010, we would argue that it has no res judicata value, therefore Truax should apply. But again, we believe under Ellis or Truax that we believe we've shown the evidence. What is the evidence? Exhibit 29, Bait 98. Juvenile court substantiated Danielle's physical abuse and negligence in 2008, and there's been testimony on that. We would argue that presumption arises on that, but that they would say, well, that was a long time ago. We also show CPS a warning to her, educational neglect on the same Exhibit Bait 122 on 12/3/14, specifics on Bait 124, absent 28 days, tardy 10. So she has had a lot of notice about this from CPS, which essentially did nothing in 2014.
Before you leave that point, I mean, you say that the child support case, which is a welfare subrogation case, and the PPO case, and the, those aren't custody determinations, but we had a dependency case. We had a case plan, we had a placement, we had a return of the child to her. How is that not a custody placement?
This was our argument because it didn't give him any visitation rights, and since...
Well, he didn't assert them, and he wasn't found to be the parent for another couple of years. Even if I didn't, listen, just because he's told by somebody he had a casual relationship with that he might be the father, doesn't mean that he knows he's the father. And, but, I think his testimony was compelling and credible, that there were a lot of things going on in his life that have changed.
Oh, absolutely. I'm just trying to get to what test should the court use, and either Ellis or Truax, we would argue it doesn't matter, but I just bring it up as a legal point. Since it wasn't in, his visitation wasn't in that order, there was no res judicata effect, but I'll move on. Severe educational neglect, start with Norman Boxa, his current teacher. Dustin's in 2nd grade but operating in a kindergarten level, which means he's learned nothing in the mother's care, we would argue. Mom doesn't agree the boy is emotionally disturbed. Danielle disagrees with the school IEP. According to Mr. Boxa, in the last couple of weeks the boy has improved, we believe, due to Dad's efforts in working with him, because this is the only time he's improved, as far as we can understand. Mr. Boxa testified Mom filed a civil rights complaint against him. And his IEP meeting, and I believe it was in December, one of them was supposed to be in December, had to be rescheduled twice due to Danielle. Exhibit 31, Bay 289, is his school records, absent 143, AM 137, PM 280 total. And Bay 283 to 288, we can see the specifics. This means that Dustin is essentially at a level where he's just, a kindergarten level, he's just starting school, simply because Danielle did not assure he'd go to school. There's been a lot of talk of implication that she homeschooled. Well, she couldn't homeschool, consistent with NRS 392.040, which mandates attendance at public school, exception under 070 is private school or homeschool. 070 refers to, if you want to talk about homeschool, 392.700. And I know the court knows this. Under 700, notice must be filed. Under subsection 5D, you must provide a parenting educational plan as per subsection 12.
Let me ask you this may be just kind of just a curiosity for me, is that parent takes their child out of school, they don't homeschool them properly pursuant to the law. Why no dependency case? I mean, you take a child out of school for half a year or whatever, no abuse of neglect case, no nothing.
Well, that's
no
a good...
inquiry. CPS apparently contacted her and did nothing.
That's exactly right.
Wow.
But this isn't the first time CPS has done nothing. I've been practiced for 30 years, and many of the time they did nothing. But in any event, all I know is what the law is and what the testimony is here. Also, her choice of tutor, Deborah Armstrong, we allege is Deborah Armstrong was completely incompetent. I asked her extensively about homeschool. I knew the statute. She didn't. She said, if I'm recalling her testimony correctly, she said, no permission is needed if you homeschool, and no, you really don't have to do a plan, an educational plan, and that's just not right. Also, there was, we questioned whether she was even credentialed as a teacher at the time, because there was a dispute in testimony. My client believed she was fired as a form of a teacher, and she testified she resigned. So there's a question of credentials. The bottom line is, Deborah Armstrong was completely ineffective, and she testified that 6 hours a week is no substitute for 36 hours in school. She testified that mom took the child out of school, and there's another testimony in January 2014. She believes, it's strange, there's been testimony that the mother believes the child has autism. And I asked Ryan about that, the teacher, and he said he hasn't seen anything. And Deborah Armstrong testified that she believes he has autism because took him to a movie when the boy was afraid, upset at loud sounds. And I would assert that's completely illogical. And I believe that's where Danielle may have gotten this idea that he has autism, and there's no proof. This is a delusion, because there's no proof that he has autism, which would be a very important label. Moving on. Evidence shows substantial change of circumstance from the date of the 2010 order. Number one is the exhibit, his educational exhibit, testimony of Ryan Tomiano, concerns about mom's stability. That's what the therapist testified to. There is one about Jason. He called CPS Center 2014 Educational Neglect. That's a link to the CPS records, BATE 122, as to the specifics of what they talked about. It's about his absences. Testified child does not have autism or neurological problems, no evidence seen by him, contrary to Danielle's assertions. Mom won't let Carol Allen, paternal grandmother, who child loves, work with Mr. Tomiano. We would assert this is interference with the best interests of the child. Why wouldn't she allow this? And that has to do with 125.480, frequent contacts, won't let therapists observe the boy in class. That's direct interference with his job. His job is to observe him. He wanted to, she wouldn't let him. She has problems with the school district, asserts she and the boy are not treated fairly, and there's no evidence of this whatsoever at all. Credible evidence. And we would note that the evidence shows when he acts up, he's got oppositional defiance disorder, and that's why I went through all those pictures. We believe those pictures, her testimony of the pictures, clearly paint a picture of real defiance against authority, not just police officers, but the world. And it basically is giving him gangster ideas of defiance. And we believe that's where his oppositional defiance, which we allege is his biggest problem, comes from. Exhibit 36, the IEP. Evidence of mom's interference, dated January 5th, 2015. Quote, ADHD not well controlled. Mother not compliant with neurologists or pediatricians, other psych disorders, and asthma. Dustin enrolled in prior school 19 days, absent 11. Current school enrolled 60 days, absent 39. Tardy 10 days. 50 full school days absent. And this is their bottom line. Continued absences will result in further loss of potential academic progress. When my client saw that, that is the fuel that fueled this litigation. Instability. Going down the list, testimony of Cynthia Roberts regarding the eviction. She testified that she offered to waive $2,000 essentially. That's not what exhibit 3 shows. What she actually said was, I will tell, she admitted she would lie to the child support division, say he paid $2,000. That's dishonest. Exhibit 31, the transfers. Even though she didn't move, changed the boys' school 3 times. CBA 290, 293. We would assert this is a created instability in Dustin's life. Having to go to another school, new teachers, new friends. Well, I guess it would be 3 times in the last 4 years. Why? For what? Best interests, stability, to be with dad. He has a loving relationship with this child, despite her testimony that she basically would only allow supervised visitation until you ordered it, which we would assert is contrary to frequent contacts and associations under 125.480. He testified he has a nice home in California, he's bonded with the child loves him, he loves the child likes California. More importantly, he has an educational plan for Dustin already met with the tutor. We think that's important. He has plans for a therapist as well. Summer school this year for more education to get him on track up to the 2nd grade. He has extensive family support in California. He won't have to leave the child with a babysitter. Babysitting, reinforcement of rules and proper behavior, structure for studying, structure for manners, medical insurance for the boy. Education would be a priority, not a problem, and he would ensure the boy go to school. Probably most important than all, he testified that in his care, Dustin, when he acts up, is controlled, and he's learned that it's not acceptable, so Dustin is a different boy in his care. Well-mannered, but he does act out in her care because I believe she testified at a certain point she couldn't control him. NRS 125.480, frequent contacts, conflict, stability, emotional fitness. The evidence shows that she is in conflict with everybody around her. She's in conflict with Carol because she won't let the therapist work with Carol. Exhibit 3, she calls Carol an N lover. I don't even want to say the word, N lover. She's admitted that she wouldn't let Carol, this was a couple weeks ago, wouldn't let Carol pick up the child at school. She insisted the child go to her at 5 o'clock, but of course that's not really an excuse because she didn't let Carol pick up the child at 5 o'clock. She agreed that Dad had to pick up the child, and because he did have to pick up the child, he wasted that window. Now he's in the window on Friday with all the cars going from Vegas to California, getting late, and she complains because he arrives late. Well, she caused that lateness. December 4th, she flatly testifies she just denied him visitation. At first she said that he had a doctor's appointment, but if you'll notice her testimony, I asked her, is it true that she never gave him the list that you ordered her to give? We recall that you ordered her to give. In her exact words, I don't have to give you S-H-I-T when she said, oh, you can't have Dustin on, this is on December 3rd, you can't have Dustin on December 4th because he's got a medical appointment. That's what she told him. And he's asking for the medical information. And in our exhibit, she says, that's exhibit 32, Bay 294, 295. She says several things. She says, Carol's not getting it, neither of you. Foul language. And she says, I'd like to quote her exactly. I don't have to give you S-H-I-T. And that is in I'm sorry, exhibit 34, Your Honor, Bay 298. I don't have to give you S-H-I-T. And what she's referring to is his request. It's been 24 hours. You still haven't given me the information on the doctor's appointment. I need the time, name, and phone number of the doctor. That's on Bay 297. She concludes on top of page 298, I don't have to give you S-H-I-T. That has been her position, and that was just last month. I'm sorry, that was in December of 2015. Despite this, he is on the list. There is no truth. If he were to testify, there is no truth that he screwed up the meds. That's completely not true. And there's no evidence of that other than her good word. Moving on, Exhibit 32 shows her negative attitude towards Carol and her negative attitude towards him. Negative attitude towards the teacher. Chump-ass buddy teacher of yours like to visit, done effed up by saying just what you wanted him, huh? So she's against Ryan because she thinks Ryan is an ally of Jason when in fact he's Dustin's teacher. He's trying to be honest with the court. Then she says what was required. This is on December 3rd, when she denied him on December 4th, the day before. I don't give a F, call the police, you're not getting him. And he didn't. He drove 600 miles from California and he had to leave without the child. So she's also in conflict with this court. You established the visitation and she violated it. Jason's testimony, February 5th, week prior to trial, Karen not allowed to pick up the child from school at 3 p.m. I've gone over that. That's a denial of a couple of hours. But it illustrates that she's not going to obey your orders if you allow her to keep the child. If she doesn't obey your orders when the scrutiny is on her, why would she obey your orders afterwards when the heat is off her? And it goes to 125.480, frequent contacts and associations. Exhibit 3, Bay 5 through 12. We've gone over that, her dishonesty. Also, she admits she stole a bottle of alcohol. It reveals what she really believes about Jason's mother and that she's an N level. Moving on, our other proposed exhibits, the eviction order showing instability as late as last year. We would argue that if since rent is only $321 a month, why couldn't she pay it? Why was she behind in arrears? Exhibit 5, Bay 18, F the police. And she agreed with me that this is not exactly appropriate, but her explanation is Dustin can't read. Well, Dustin can read. Exhibit 6, Bay 20 to 23, Justice Court records on her, municipal court records on her. The court can see that, I'll skip over that. She has constant conflict in her life. She describes Eric Germano's domestic violence, and I asked her, was Dustin there? She says yes. So she's had a very unstable life, and Exhibit 12 shows that. Bay 37 through 75. Exhibit 12, Exhibit 13, 14, 15, 18, and 19. Bait 83, Exhibit 22, Bait 83 is a standby card on December 4th, but since you admitted that, I don't have to go there. Exhibit 27, Exhibit 27 is internet snapshot of Dustin's webpage, rife with profanity, gangster language, sexual innuendo, and defiance. Totally unsuitable for a 7-year-old child. Again, I asked her about this. I said, how could this be good for the boy when he's got oppositional defiance and this appears to fuel that. She said she will take them down, but she hasn't yet. And not reading is no excuse because he can see the pictures, and he really can read. He missed school this week, he missed school last week. Her testimony that Dustin has insomnia doesn't explain anything, because unless she has insomnia, why can't she get him to school? She can't get him to school. If you leave the child with Dustin, we believe the evidence is overwhelming. Nothing is going to change, nothing at all. Other exhibits, Exhibit 33. I'm sorry. Exhibit 37 are good color pics of the Facebook page. In any event, Your Honor, I don't want to belabor it. We would ask for an order awarding him primary custody. We believe we have presented evidence not only of a substantial change in the child's position since the last order, and under Ellis, certainly educational neglect is certainly recognized as one of those important things to be used. Best interests. All we know at this point is that Dad is set up to take care of the child in California and to do that which Mom apparently can't do, which is not just get him to school, although that's important, but to work with the school, to work with the tutor, to work with the teacher, to get a good tutor, and to teach the boy manners and structure. We're talking about structure here and solidarity. Structure to learn not just schoolwork, but how to view the world. That he doesn't have to be in defiance of others. And I would assert that there's plenty of evidence on that. He doesn't want child support. He would ask for a tax exemption, and we'd submit.
Thank you.
I ask the court to consider my pretrial memorandum and the arguments contained therein without belaboring and just repeating what is in there. From our position, it's obvious, it's undisputed that the minor child has resided exclusively with Mom since the date of the child's birth. I believe it's undisputed that until Dad took action to file in this case, that he had virtually no contact. I don't believe, the court can draw its own conclusions with regard to the attempts made by Dad to see Dustin prior to the initiation of these proceedings, but they were very thorough, and I believe if there were significant efforts made by Dad and or Dad's mom to see the child, there'd be plenty of text messages and everything else contained in their exhibits showing that they made these attempts and that Danielle denied all these attempts. I think the evidence established that Danielle did facilitate contact with Dad, and especially with Dad's mom, who was here. I think I'm pretty sure my view of the situation is I think Jason's mom wanted to have contact. Jason's mom wanted Jason to have contact, but for the vast majority of the child's life, Jason wasn't interested in that. He was pursuing his own interests in California. He left the state when he discovered the fact that he was in fact the biological father, rather than take actions at that time, which is what he should have done. He took no action at that time, and he took no action until 5 years later. In the meantime, my client was on the front lines dealing with a child who obviously has significant emotional and some medical issues. I think that's been absolutely established. I don't know that you can state in this case that she's been neglectful, because all she has done is seek out medical treatment for her son. That is obvious. She's had him in counseling for 2 years. She's seen multiple physicians for this child. She has been to IEPs. Dad was absent during all this. There's no evidence that Dad ever attempted to do anything about it until July, or whenever he filed this case. The education thing, it's the obvious problem in this case. I think the court needs to make a decision. Is it going to just make a radical change in custody based on some of the educational issues that we have when the child has been placed in school while she's working with the principal, working on the IEP? I think it's clear to me that although the educational situation is not ideal, every action that Danielle took was out of her belief to protect her child. Whether that was wrong or not, based on some of the court's comments, it may not have been the right thing to do, but everything that she did was motivated out of what she felt was in the best interest of her son. It wasn't out of neglect or because she's partying. Certainly the court has seen neglectful parents that aren't getting their kids to school because they're out partying or they're not getting up on time. I believe if you look at the child's current educational level, I mean, his teacher, when they're trying to portray Dustin as he's way behind and it's mom's fault, and ask the teacher, what level is he at? Well, he's way behind. He's kindergarten level. And my question to him was, well, how many kids in your class are at grade level? None of them. None of those kids are at grade level. Not one of them in his class. His current educational level, I believe, is a direct result of the disabilities that he has that have been specifically identified by the school district, that have been identified by his doctors. And again, it hasn't been ideal, but the child has been in school. She's working with the principal. They're gonna manufacture a new IEP or do further analysis of the situation and take remedial measures to try to get this thing resolved. And it's not accurate to state that if you maintain custody with mom, that there will be no improvements. I think it defies a little bit of belief to state that dad having 3 or 4 visitations is all of a sudden resulting in improvement of the child. The improvement of the child, I believe, is the result of mom's efforts in keeping this child in counseling and doing everything that she can for this child. It's only been mom that's been there for this child from the very beginning and not dad. Certainly Danielle has faced many challenges in life. That's obvious. She's had surgeries. She received no financial support from dad. It's wonderful now that dad's paid off all these arrears, but mom certainly could have used the help in 2010 and 2011 and 2012. Where was dad?
Yeah,
Dad?
she wasn't going to get those monies. That when she received state benefits, she assigned her rights to collect support to the state of California or the state of Nevada. So that's a red herring. Okay, child support was established because she had to be supported with assistance from the state, and that's why it was so. That they were willing to take the minimum because it was not going to her, right?
I guess, Your Honor, Dad's gotten off pretty easy on this thing. He hasn't had any responsibilities up until now. I understand he wants to assume responsibilities.
It is an irony in that if this case had been litigated 2 or 3 years ago, he probably would have paid 2 or 3 times the amount of support that what he's paid back to the state of California or Nevada. Yeah.
So again, without belaboring the court's aware of all the facts. I can go into the ridiculous Facebook stuff. The child isn't on Facebook, so I don't know why they keep arguing that.
Well, that's because the account's in his name. Look, you have to comment on the judgment of both parents. You just did about his judgment. It's fodder for argument and consideration. Her significant other establishes a Facebook account in the name of a 5-year-old, and you post inappropriate stuff on it, which essentially puts them in a poor light in the community amongst. If I was a father and I saw my kid's Facebook account having that kind of stuff on there, I'd be furious. It's not. It's just poor judgment. That's all. Does it arise to some sort of? Is the child being affected by it? No, it's probably more of an effect on the parents than it is on the.
Okay, well, so the court clearly then understands the issue that the child is not exposed to those things. Again, just all the actions that she's taken the testimony by both of our witnesses established that she's a dedicated parent and has been a dedicated parent. Her whole life has been dedicated to this child. They have a very close and loving relationship. And to uproot this child, measures can be taken short of taking the drastic step of changing custody and yanking this kid away from his mother. The only real who he has established a long-term loving relationship for 7 years. You can make a conditional order, something less extreme than that. I don't believe it's in his best interest, given his significant emotional issues, to uproot him from his mother and place him with dad in California. I just don't see that. I think there can be orders that can be less than that, maybe in terms of, you must keep this child in school, and if you don't, then I'm going to consider a change in the future. Mom needs to be given a chance to continue with the current situation where the child is now, to work with the principal. And if it doesn't work out, well, maybe then make this drastic move. Because it is going to be a drastic move. I mean, I don't think there's any question that this child is very emotionally vulnerable. And to make a move like this, a drastic move to what was a virtual stranger, I don't think it's in his best interest. And
Does I know this is a question sort of out of left field, but is the paternal grandmother a Nevada resident? Does she live here? Or does she live in California?
she lives here, yes.
Okay, all right.
Well, that's another thing I was going to say is that, plus these if the court's going to maintain Danielle with primary, I think at least one of the weekends Dad should be required to stay here so that we don't have 4 trips per month of the child going back and forth to California. I don't know what their position is on that, but he has the opportunity to stay with his mom on these weekends. He's coming in late on Friday, and then they're driving. I don't know that it's in the child's best interest for that. I understand it's problematic, but Dad did create the problem by moving to California after he was established as the parent, so maybe he should suffer a little bit because of that. He can stay here one weekend, and then maybe another weekend he can take the child to California. He can have spring break. He can have time during the summer. He can have time during Christmas. Again, without belaboring everything else that's in my pretrial memo, unless the court has any questions for me,
No. Thank you.
we rest our case.
Mr. Root, were any final points of clarification or reply?
Well, yes, Your Honor, I just wanted to emphasize that the representation that he's only had a couple of months of visitation is completely untrue. He's been visiting this boy all the way back to 2010. As a matter of fact, the mother testified that in 2008, she 1 week old, she comes to his house. That's her testimony. He testified in 2010. He had frequent contacts, but they were limited, if the court will recall, to 1 every 3 months. And they were always in Las Vegas. So we're not talking about somebody that's had only 5 or 6 months of visitation, regular visitation. She has allowed him visitation, and it's due him that he would come to Las Vegas. Well, he testified once every 3 months, all the way back to 2010. So if their theory is that this child is an absolute stranger, that's simply not true. That's not what he testified to. That's not what she testified to. All she testified to was she wanted supervised, she had him on supervised visitation, and he would come. So we're not talking about a complete stranger. We're talking about a boy who's known who the father is for years, since 2000, and I guess when she decided to tell him, which is 2012, but during that time he still visited the child. So there is no evidence at all that there would be any psychological harm to Dustin if he were to move to California. This is an emotional argument. It's not based in fact. It's not based on a psychological report. It's not based on anything. It's just a sympathetic tearjerker laid out with no evidence at all whatsoever. Now, obviously, there's going to be some effect, but the court can minimize that with an order saying, giving her generous time, but they completely ignored the fact that educationally, in her care, he's been quite severely handicapped, and also, we would argue, socially, frequent changes in schools, no structure whatsoever, and I'm talking about brushing your teeth, changing her clothes. Here the child is 7 years old, and she buttons his shirt. She had him in a stroller until age 6, which I would assert is completely unfit. What evidence does the court see, medically or psychologically, that this 6-year-old needs to be in a stroller? That's absurd. That's unfit. Also, she doesn't need, this boy doesn't have to do anything in her. He's not going to develop in her care. He needs to be buttoning his own shirt because she delusionally believes that he's got pain in his arms, whatever. We've had plenty of time for discovery. There's no evidence of that at all. It's all in her mind. And as long, if the court leaves this little boy with her, that he's going to grow up severely dependent on her to do everything, including button his shirt and to clothe him. We would just assert that's a big one.
Is your client going home this afternoon?
I do have school tomorrow.
All right. You're going to have you arranged to be able to see the child while you're here?
This is my weekend in Las Vegas.
All right, great. Then all right. The matter will be on my plate to try to resolve by next week. Sherry, thank you for helping us covering this hearing today and sticking with us Thank you, counsel. Appreciate it.
Thank you.
Thank you, Your Honor.
And thank you for allowing me to make that call, Your Honor, on that other case.
Yeah, anytime, anytime.
I was gonna tell Judge